Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk titled Living Trust versus Testamentary Trust. What's the difference? My name is Thineshvary Maniselvam. I'm a pupil in chamber with MWKA Associates, and I will be your moderator for today's session. Now, before we begin, let me introduce the firm and what we do. MWKA Associates is a mid-sized law firm that was founded in 1985 by Dato' MWKA. Our able team today comprises 28 lawyers and a support team of 21. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment, industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice group indicates some of our focus areas, which are supported by talent from our corporate and dispute resolution team. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Moving on, our speakers today are Mr. Chong Chieh and Ms. Rachel Ng. Allow me to introduce our first speaker, Rachel Ng. She is an associate in our dispute resolution and individuals and family departments. She obtained her Bachelor of Laws with honors from the University of Northumbria, Newcastle. She was admitted to the Bar of England and Wales in 2020 and then later on to the Malaysian Bar in 2021. Her areas of practice include construction litigation, general litigation, family law matters, citizenship, and probate and administration matters. Our second speaker, Gan, is a partner in our dispute resolution department. He graduated with a Bachelor of Laws with honors from the University of London and completed his master's in international economic law, East China University of Political Science and Law. He was admitted to the Malaysian bar in 2009. Gan practices in the areas of general litigation, debt recovery, construction, wills, probate and administration, arbitration, family law, disputes by management corporation and joint management body, and criminal law. Moving on, we will also be having Q&A session at the end of the talk. So please feel free to type your questions in the Q&A chat box at the bottom of your screen. Without further ado, I now pass the time to our first speaker, Ms. Rachel.
Thank you, Thineshvary, for the warm introduction. Good afternoon, everyone, and welcome to our last online talk of 2022. There will be 4 talk points today. The first being understanding living trust, its users and benefits. I'll continue with revocable and irrevocable trust deeds. Thereafter, my colleague Gan will take over to discuss on testamentary trust and its limitations, and then discuss on any possible dispute and case studies. So what is a trust? Trust is a legal entity with separate and distinct rights. It is akin to a person or a corporation. So there are 4 elements in a trust: the settlor, the trustee, the beneficiary, and the trust property. So the settlor is the person creating the trust, and the trustee is the person who holds the subject matter of trust, usually property. The trustee's obligation is to manage the trust for the benefit of the beneficiary as per the wishes of the settlor, which is usually outlined in the trust deed. Under a trust, the legal title will be vested in the trustee and the equitable title in the beneficiary. Let's discuss what are the benefits of a trust. The trusts are versatile instruments used to achieve specific goals. It can prevent the dissipation of assets by spendthrift beneficiaries. Trusts are usually established to provide legal protection for a trustor's assets. Trusts ensure that assets are distributed according to the wishes of the trustor while reducing paperwork and reducing inheritance or estate taxes. Trusts also ensure that the beneficiaries who are minors will be looked after financially. In the event of death, the funds are immediately disbursed without having to go through the probate or administration process. Today, I will be sharing about 2 kinds of trusts. So the first being a living. Living trust allows a trustee to manage assets in the state trust, which is to be transferred to the beneficiaries after the settlor's death. Living trusts start with a trust instrument, which is created during the lifetime of the settlor. A trust instrument is in the form of a legal document, which lays out the rules and provisions of the trust. This trust instrument is commonly known as a trust deed. So this trust instrument can name the beneficiaries of certain assets, which would otherwise flow directly to the state beneficiary. Unlike a will, living trusts take effect while the settlor is alive and does not go through probate for assets to reach the intended beneficiary when the settlor dies or becomes incapacitated. So what kind of assets can you include in a trust? So assets which are to be assigned to a living trust are retitled to indicate ownership by the trust. The types of assets permissible to be assigned can range from real estate to financial accounts, personal property, business interests, and even specific financial accounts ranging from stocks, bonds, certificates, mutual fund accounts, brokerage accounts, money market accounts, cash, and so on. Setting up a living trust can ensure the settlor's estates are protected against negligence claims, creditors, and bankruptcy. So there are quite a few benefits to having a living trust. The first would be that you can avoid probate, as probate processes can be and are often costly and lengthy. Assets in the trust can be transferred directly after the passing of the settlor, saving the loved one's time, money, and trouble. The second benefit is privacy. Probate processes, it does include making content of one estate as public information. So this trust ensures information like ownership and the value of property, as well as information about beneficiaries, remain private and confidential. The third benefit would be the control and flexibility that you have. Trust can outline specific guidelines for how you want your property to be handled after your passing. So adjustments to a trust can also be made fairly easily. The fourth benefit is protection. As trusts can take effect during the lifetime of law, it is also beneficial for situations of incapacity, such as illness, paralysis, and so on. This is to prevent conservatorship. Living trusts are also more difficult to challenge in court than a will, as it is harder to prove incompetent. So there are primarily two types of living trusts, revocable and irrevocable trusts. The most common form of trust deeds nowadays are revocable trust deeds. The difference is that irrevocable trust deeds will transfer the ownership of the estate and of the settlor's asset, and the settlor is unable to name him or herself as the trustee. So upon demise of the settlor, a revocable trust will convert into an irrevocable trust. So what is a revocable trust deed? So the creator of a revocable living trust, the settlor, would retain control over the named asset. The settlor can also name him or herself as the trustee. The revocable trusts are usually very flexible and can be amended at any time by the settlor. Amendments can include things like change of beneficiary, change of trustees, removal of the assets from the trust, or even termination of the said trust at any point in time. As the assets will still belong to the estate of the settlor, they are taxable, which are paid for by the settlor in their lifetime. Revocable trusts usually have upfront costs and may require many steps to fund. And for a revocable trust, a trustee may be assigned to manage or distribute the assets within the trust. So what are the advantages of a revocable trust? The main objective of revocable trust is to avoid the probate process. Revocable trust deeds also ensure the easy transfer of assets to the intended beneficiary. This trust is often used to protect assets should a settlor become incapacitated or otherwise unable to control his own assets. The settlor can usually choose a plan to distribute the assets over time to specific beneficiaries. The second type of trust deeds are the irrevocable trust deeds. So this trust deed is not as flexible. The trust is the legal owner of the named asset, and the settlor will relinquish certain rights of control over to the trust. Once created, the named beneficiaries are set, and the settlor can do very little to amend the state agreement. Amendments are still permitted, but only under specific circumstances, with certain changes requiring approval from the court. Assets which have been assigned to an irrevocable trust cannot be taken back, and there may be income tax and future estate tax implications to be considered. The advantages of irrevocable trust is that it provides ultimate protection of the estate from any lawsuit or any claims from creditor, as the settlor is no longer the owner of the state estate. Irrevocable trust deeds often considered by individuals which are vulnerable to litigation. This irrevocable trust can also ensure that the assets will pass along to the named beneficiary. I will now pass along the session to my colleague Gan to discuss testamentary trust. Gan, over to you.
Thank you, Rachel, and thank you, Thinesh, for the warm welcome. Good evening, everyone, and thank you for attending today's talk, Living Trust versus Testamentary Trust. As we have heard Rachel sharing on Living Trust, so now I will continue to discuss on what's Testamentary Trust and how do we actually understand Testamentary Trust. So Testamentary Trust established according to terms laid out in a last will and testament. The difference between what was explained by Rachel is the living trust, whereby the trusts are formed by way of a trust deed, but a testamentary trust is the trust falls within the four corners of the last will and testament. And because the trust falls within the last will and testament, the terms of the trust or the terms of the testamentary trust only takes effect upon death. So the fiduciary relationship allows a trustee, a third party, to manage assets on behalf of the beneficiaries of the trust. So a fiduciary relationship here basically means that a relationship of trust and confidence placed by one party, which is the testator, on the trustee, and to be relied by the beneficiaries that this trustee will actually act for their benefit. This is the understanding of fiduciary relationship. So when a will is prepared, it's capable of having more than one testamentary trust. It could have a few, and depending on the needs and also the intention of the testator or the will maker. So the testamentary trust encourage for overall wealth management strategies as they provide specific instructions for the distribution of assets. So some people, why they have testamentary trust, or some people why they have trust deed, is because certain instructions, they only want it to take place upon death. And maybe certain families, they are rich enough, they do not want certain part of the assets to form part of their estate after death. Hence why they create a testamentary trust deed. Hence, the difference here would be if some of the big families or testator, they want their assets to be only distributed, or perhaps their kids are still young and only to be transferred or to be inherited by the kids upon his death. But yet the kids are still young, hence why they have the testamentary trust to form part of the last will and testament. Testamentary trust can also ensure professional management of the assets. So when in the last will and testament, the testator may have engaged another party, perhaps the executor or even some other party, which has the experience or whom has the experience to actually manage certain funds. Hence why they can actually get some trustee with professional experience to actually assist the beneficiaries to manage the funds. Testamentary trusts do not avoid probate processing fees, basically because you have to prove your will in court, so you have to go and obtain probate. Yes, like what was shared by Rachel, so you have to go through probate, you have to perhaps engage a lawyer to go through this process. Testamentary trusts are also often formed to manage charitable distribution of assets in accordance with the final wishes of the deceased. Generally, there are two types of testamentary trusts. One is fixed and one is discretionary, which I will come to it later. So in the creation of testamentary trust, discretion in handling of assets after a beneficiary later becomes bankrupt or encounters unforeseen circumstances can be maintained. So this testamentary trust can have terms and conditions to prevent a situation where later if the beneficiary becomes bankrupt, it prevents that this asset will form part of the bankrupt debts. So it can be done to prevent that. And it is also able to prevent assets from being dissipated prematurely. And testamentary trusts are ideal for beneficiaries that are unable to handle lump sum benefit responsibly. Like again, I said, perhaps when you have minors or perhaps the beneficiaries are too young or they are a bit immature to actually handle a big, huge amount of money. So testamentary trusts are ideal, whereby can be distributed in tranches in accordance to their age, for example. So what's a fixed testamentary trust? A fixed testamentary trust here whereby the beneficial interest, or let's say, for example, the assets are fixed so that the share received by a beneficiary will be defined to the terms of the testamentary trust. So basically, the testator will set out everything in the will, setting out, for example, beneficiary A, how much they will receive, when they will receive, how they will receive, perhaps what are the tranches for the trustees to actually release these monies to them, or the assets to them. And the difference with discretionary trust will be the trustee in a discretionary testamentary trust will be given a broader dispositive direction. Basically, they have the power to decide how this trust income or the capital can be managed. And once there's profits or when there are income, then they distribute according to their own discretion. So the discretion conferred on the trustee here allows them to respond to changing circumstances when administering the estate. So there are definitely pros and cons. It really depends on what are the assets and also what is the trust funds. So what are the limitations of testamentary trust? So again, like what we have said, the will has to go through the probate process and you cannot avoid a probate cost. So that's one limitation that maybe to some of the testator, I may feel that, oh, I don't want to pay probate costs, so perhaps I should set up a trust. A trust can also expire. So for example, once the beneficiary has reached a certain age, then the trust will come to an end. Or when the trust fund has depleted, before even the beneficiaries reach a certain age, then the trust will have expired. Or other limitation will be if an appointed trustee is unwilling or unable to act, then the beneficiaries may have to go to court and to request them to be removed and to appoint another trustee. When there's a testimony trust, testamentary trust in the will, the contents will become public because when we apply for probate, for example, once there are public records, file search can be made and can get a copy of the will. And should there be any confusion or lack of clarity within the will in respect of this whole testamentary trust, then details could be overlooked and wishes of the deceased or the testator may not be executed properly. Hence why this is a situation where a testator who intends to incorporate testamentary trust into the will is advised to actually seek legal advice. So what are the possible disputes that may arise from a testamentary trust perspective? So as property is first transferred to a trustee, then the assets are held on trust by the trustee. So the trustee here in the situation may just hold on indefinitely or without even complying with the terms of the will or even the trust. So then there may be a disagreement that arises between the beneficiary and the trustee as to why was the property not being transferred? Why is it that you are holding it for such a long time? So these are things that or disagreements that may actually crop out from being a trustee. A dispute may also arise in the form of beneficiaries disagreeing over the construction of the trust. So perhaps the wording or the terms of the trust are not clear enough, and the beneficiaries felt or think that the terms should be read in a certain way, and the trustee actually read it or interpreted it in a certain way or another way. Hence, the disagreements may arise from different interpretation of the terms of the trust. So dispute may also arise with regards to how a trustee is actually handling and administering the estate. So this, for example, misappropriation of funds, or for example, funds are actually put together with his own personal assets, or perhaps also a situation where the testator intended the property to be used for to generate rental, for example, but then the trustee is actually staying in the property. So these are things that may create dispute and acrimony between the beneficiaries and also the trustee. So what are the possible remedies for trust disputes? So in the circumstances of mismanagement by a trustee, then of course the first step is usually by the beneficiaries were to say to remove the trustee. Let's say, for example, in the will, it's proven there are elements of duress or fraud. Then the beneficiaries can perhaps bring the matter to court, bring the dispute to court, get the court to adjudicate the trust or the terms of the will to be partially or fully void, meaning to set it all aside. So to avoid all these disputes, the maker of the trust, again, we use clear and unambiguous language, keep proper records of documents to support the whole trust or the terms of the will. And again, in situation like this, it's always better to get legal representation to actually advise on the drafting of the terms of the trust. So now going to the case studies, let's start with Hong Kong. So in the case of Tan Mei Kam against HSBC International Trustee Limited and others. So in this case, the deceased executed a will where she bequested her entire estate to a trust, which was set up on the same day, immediately before executing the will. So specific instructions were left as to how her assets were to be distributed according to the trust. However, the plaintiff had discovered the contents of the will, part of the contents of the trust, and also something called the trustee memorandum in this case. So being dissatisfied, the plaintiff sought to challenge the validity of both the will and the trust to declare that the deceased, having died intestate, and in order to grant the plaintiff letters of administration in respect of the deceased estate. So in this case, Tan Mei Kam was the mother and the deceased was the daughter. So in challenging the will and trust arrangement, whereby the mother actually challenged the will and the trust arrangement on grounds of mental capacity. So the Court of Appeal found that the deceased's mental capacity to make a trust has been duly established. She had complied when making her will. She has done all that is necessary to comply with the requirements of the will. And the Court of Appeal has found that the deceased knew and approved the contents of the will and also the trust arrangement. And this case is interesting is because Tan Mei Kam is the mother of the famous Anita Mui. So the case that I've mentioned earlier was the case of the famous Hong Kong cantopop diva Anita Mui. So in Anita Mui's case, she has prepared a trust and also a will. But as we all know, based on reports from newspaper, Mrs. Tam, or Madam Tam, should I say, is a compulsive gambler. And Anita Mui is well aware of that. Hence why she has created a trust and also her will. And her residual of her trust upon the death of Madam Tam will go to New Horizon Buddhist Association, if I'm not mistaken. So there's a monthly expenses or expenditure being paid out to Madam Tam. And of course, she's unhappy with it. Hence why she has always mounted a few suits to actually challenge the validity and both the validity of the will and also the trust. So this snippet here is something that I found online in 2019, where this is after the case that I mentioned just now. Madam Tam wanted to celebrate her 95th birthday. She went to court to get more money, basically, from the estate. Yes, the court here granted Anita Mui's mum was granted Hong Kong 250,000 to celebrate her 95th birthday. Next, we will go to Singapore. So in this case of Yusof bin Ahmad, so here the plaintiffs wanted to remove Hong Kong Bank Singapore Limited as the trustee. So here the plaintiffs alleged that the trustee has failed to do the following. So I just list out some of the allegations here as to or the grounds for the removal. And these are the usual grounds that will actually crop out. And most often than not, we will see when we are having trust corporation, for example, to actually manage a trust. So in this case, what was the allegations or the grounds for the removal? Here was to act as trustee. So they have said that Hong Kong Bank Singapore trustee has failed to act as trustee of relation and the charity settlements in breach of the terms of the family settlement, to inform the beneficiaries of the terms and fees of their appointment as trustees, failed to act properly in relation to the distribution of income from the Australian investment in repatriating overseas income to Singapore, and thereby subjecting non-resident beneficiaries to Singapore tax. They also failed to make correct deductions for withholding tax in respect of the income for year 1986. They failed to take safe custody of trust documents. They failed to invest trust funds, authorized investments in Australia, and failed to disclose to the beneficiaries the advice of the Queen Council on how to deal with the Australian investments. They failed to remit the sum of USD 477 to a beneficiary, which as a result was paid 5 months late. And also they failed to avoid incurring unnecessary expense in taking advice from solicitors on a claim merely involving 371 Sing dollars. So of all these grounds and allegations or complaints made, the court actually found, by the way, there were more complaints. I just picked up the necessary ones. So the court found that some of the complaints were very trivial. But in the court's view, all the above complaints, if taken collectively, would have been sufficient grounds to actually remove the defendant as the trustee. So in this case, the Hong Kong Bank Singapore trustee was actually removed. Not based on, the court went on to dissect each single ground that was raised, but taken it as a whole, the court felt that the grounds were sufficient to remove the defendant as the trustee. So in the Malaysian case of Liga Fernandez against Eric Claude Cook, so the relief sought here by the plaintiff is two-pronged. One is for the revocation of the probate, and the other relief sought was for the removal of the defendant as executor and trustee under the will. The reason being the defendant, basically Eric Claude, was out of Malaysia for a continuous period of 12 months. So the court held that because the defendant had been an absent trustee to effectively execute his duties as a trustee, the estate could not have functioned properly and fully administered. And so here, for example, payments to 3 charities named under the will were never made because the defendant was not around in Malaysia to actually sign off checks. So on these grounds, and the court invoked Section 41 to remove the defendant, as the court found that he is unfit and incapable of acting as a trustee.
So when a trustee is not around in Malaysia, for example, here is a continuous period of 12 months, the court held that this is a ground to actually remove the trustee. So in the case of Ko Chang Yeo and Ko Chong Kai, so this case concerns a trust deed for a piece of land in Penang. So the settlor of the trust transferred this land to his son to hold on trust for the land to be used as a place of interment for the family, heirs, and also the descendants. The plaintiff is the 8th descendant, and the first to 4 defendants are the current trustees and 7 descendants. So the issue here is whether the defendants as a trustees have committed a breach of trust. So the court held, yes, they have breached the trust. So what was their wrongdoing? So the second defendant has been receiving a monthly salary of 5,000, which came up to about 490. So second defendant has collected 490K. So the monthly salary was authorized by the other defendants. And the second defendant had also moved into a bungalow on the land and utilized it for his personal use. So the court found that a monthly salary or remuneration of such a nature can only be authorized by the court and not the trustee themselves. And the second defendant has also breached his fiduciary duties here, whereby he has moved into the bungalow and used the bungalow for his personal residence. The trust lost the rental which could have been generated from the said bungalow, like what I've just explained just now, where the trust wanted this bungalow or this piece of land to generate rental, to generate income. But because the second defendant is actually residing in it, so they could not have rented it out to someone else to generate income. Hence, the estate has suffered a loss. So finding the first to fourth defendants liable, the court ordered, among others, that the first defendants are removed as trustees and new trustees to be appointed and to follow the terms of the trustee. So that's my sharing on the case studies. I'll now pass back the floor to Thinesh and we'll take some questions.
Right. Thank you, Gan. Thank you to both our speakers for the insights today, for giving us a clearer picture of what entails a living trust and a testamentary trust. Now, before we conclude, we would like to take questions from the floor. At the moment, we have one by Bruno Kaur. What trust to set up for a rich widow who has no family members and no friends? She is now suffering early stage of Alzheimer and dementia. I believe this question is for you, Rachel.
Thank you, Dinesh. Thank you, Bruno, for the question. Yeah. The trust most suitable to set up would be a revocable living trust. So in the event that her dementia incapacitates her, she can then instruct the relevant person to prepare for her care. So in this case, a hired caretaker. Any assets that she has can also be specified in the trust to provide allowance or salary for her caretaker. It is advisable for her to do this as soon as possible so that her mental state does not come into dispute in the event anyone wants to challenge the trust. She can also name a trust company as the trustee to ensure that her future needs are taken care of. So future needs such as the continuous employment of a caretaker or to appoint a new caretaker if required, and also the maintenance of her property, maybe the house that she was living in, that she will be living in until she passes on. I hope that answers your question, Bruno. If parties have any more questions, I think there's a next question, Thinesh.
Oh, okay.
Yeah, maybe Dinesh, I can just answer all from the Q&A. Jared Tan actually mentioned that there was a mistake. Actually, there was not a mistake. It was a typo. So yes, the trustee was actually removed because the Singapore case, yes, the trustee was removed because of the grounds. What you saw on the slide was a typo.
Right. Thank you, Gan. The next question from Ji Sulin. Seeing these few scenarios, would you advise that an owner of a large estate, the executors of the will, be handled by corporate trustees rather than individual executors? I believe this question is from you, Rachel.
Okay, so owner of a large estate, it really does depend on how you decide to specify in your will or in the trust. You can appoint corporate trustees to handle your assets, but then do bear in mind that it will come with additional costs as well. So it At the end of the day, it really is a matter of your preference and also your executors, whether, they are capable of carrying out the duties that you would have imposed on them in the trust.
Thank you, Rachel. That answered the questions. And the next question would be by Revocable. Can legal firms act as trustees? What are the advantages and disadvantages? Would any of you like to take it?
Yes, I will take it, Thinesh. Can legal firms act as trustee? The short answer is no. If, let's say, for example, a testator or even a settlor who wants to actually appoint someone from the law firm to actually act as a trustee in his individual capacity, yes, they can. But the firm itself cannot be a trustee. Because in order for a corporation to be a trust corporation, of course, there are certain requirements that it has to be governed by the law. Then you can act as a trustee. But no, a law firm cannot. So what are the advantages and disadvantages? Since if you get an individual lawyer, for example, to act as a trustee, then of course, it depends on what are the terms of the trust. So if the terms of the trust, that is something that they can manage, they have the experience to manage, then yes, then there are advantages. Yeah, Thinesh.
Thank you, Gan. I see that we have no more questions. And since we have limited time, we encourage everybody kindly to email us if you have any questions and our speakers will address them. Before we conclude, we have a few announcements to make. Please allow me to share my screen. Firstly, please fill in our feedback form and tell us what you thought about our talk today. The link to the form will be posted in the chat below. Secondly, do follow our like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. And lastly, if you would like to speak with our lawyers, we offer a 30-minute complimentary consultation over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box as well, or scan the QR code on the screen. To our guests, thank you for joining us today. We hope you have found today's session informative and useful. And thank you, everybody. And we see you again next year.